Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Ms. Battle, could you please state your name?
My name is Denise Battle.
Thank you so much, Ms. Battle. All right, today's the day and time scheduled for a hearing in this matter. This is an action to terminate the tenancy based on non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified petition in emergency motion for injunction in the U.S. District Court, which is the case number 25-CV-11233.
Thank you, Ms. Battle.
And like I said, this court has not put on the record of their jurisdiction. There's nothing on the record, and it stands. Every notice that I've sent is unrebutted, which stands at law. And jurisdiction is a threshold issue that we shouldn't even made it this far without discussing proper jurisdiction.
All right. Anything else, Ms. Battle?
As of right now, no.
Okay, thank you.
But I object to these proceedings in jurisdiction, subject matter, and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction. Mr. Fantera, and Ms. Battle, do either of
The
you
court
have?
cannot, I object. The court
Ma'am?
cannot declare its own jurisdiction
If you
to respond to
if you keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers, so are you in jail?
I interrupted you. Okay, that's all.
Your Honor, I want to point out also that Judge Vandenberg actually addressed this issue last Wednesday and said that the 14B District Court and Your Honor does have jurisdiction over this matter. So not that it needed to
May
do
I
that.
add, Your Honor? Yeah. She also said that she was not aware of the things going on, so she just went on for anything based on what he just said. To set any law.
Welcome back, everyone. Today we're diving headfirst into Judge Washington's courtroom, where one of the most persistent sovereign citizens you've seen before is back, Karen Battle. She truly believes she can rescind her lease and live rent-free forever. But reality doesn't work like that. Over the next several minutes, you're going to see missed deadlines, jurisdictional arguments straight out of fantasy land, and a courtroom showdown that's equal parts absurd and intense. Stick with us. By the end of this case, you'll see exactly why these arguments fail, why judges have zero patience, and why logic always wins in court. Asterisk.
Ms. Battle, this court has jurisdiction and we will be proceeding today. Mr. Fantera, actually the both of you have an opportunity at this time to do any opening argument that you want to make. So Mr. Fantera, I will start with you. Do you have an opening statement?
I'll waive my opening statement, Your Honor, and just get right to the evidence.
All right. With respect to service, can you please put on the proofs regarding the service in case there's an appeal?
Say that again, Your Honor.
Can you please put on proofs regarding service in the event that there's an appeal?
You mean service of this lawsuit?
Yes, on Ms. Battle.
I believe that she was served by a court officer with Jimmy Moore's office, Your Honor. I think there's a proof of service in the file. I don't know whether it was attached or whether it was personally served. But the court has that proof of service.
With respect to proof of service, the file indicates that Ms. Battle was served with two different ways pursuant to MCR 4.201D, which is she was served, actually three different ways. She was served with an original mailing from the court, and then a second mailing went out from the court. Second mailing was requested by the plaintiff and was sent by this court. On March 28th, there was a mailing. And then there was service by Edward Cope, who was the court officer. That service was effectuated through securing an attachment to the main entrance of the tenant's dwelling unit and that was done on April 4th, 2025. And after attempts had been made on April 2nd at 12:40, and then April 3rd at 9:53, they finally did an attachment on April 4th at 4:30 p.m. In addition to that, Ms. Battle showed up to the court on April 9th, 2025 before the magistrate, therefore acknowledging that she had received service in this matter and that service had been perfected. Right. With respect to jurisdiction, we addressed that at the last court hearing. This is on Russell Court, which is within the jurisdiction of Ypsilanti Township. All right.
Yeah.
What request were you making, Mr. Fantier?
I know the last two times that Ms. Battle has appeared, she
Asterisk, and here we go, classic sovereign citizen theatrics. Karen immediately objects, claiming the court lacks jurisdiction, referencing another federal case, and insisting notices weren't properly received. Judges have seen this hundreds of times. The defendant tries to use procedural arguments to delay or derail the case. But notice how the judge handles it, calmly, firmly, and pointing out that jurisdiction was already addressed in prior hearings. Sovereign citizens often treat the law as optional, but the court makes it clear, facts and prior rulings matter, and personal fantasies do not.
as long as the court is comfortable that we can swear her in when she goes to testify.
Thank you. I am comfortable. I can tell you that if I was going to require that she be here via video, I would need to give her notice of that prior to today's date. So I'm comfortable proceeding as we are.
Okay.
All right. And Ms. Battle, other than jurisdiction, which has been noted and reserved, do you have any other argument you want to make today with respect to this matter in terms of an opening argument?
Of course. So, like I said, the contract has been rescinded on April 1st, and it was due to unconscionable pieces in the contract, including pieces that's wrong with the formation, as well as material breaches that's inside the contract. That contract has not been
You said
material breaches.
Oh, okay, go ahead.
Breaches, yes, within the contract as well. That was sent out and received. Well, it actually wasn't received on April 1st because at the end of the day, the unconscionable pieces, their addresses are wrong and the owners are wrong on the contract. So it got sent back. But once I realized it was sent and received on April 8th, 2015, and still remains unrebutted. They have yet to unrebut it in any case that we came and talked about the contract. And by law, according to Wall versus Zendaya, the Michigan law recognizes rescissions at common law for breach, fraud, and unconscionability. Meaning, if I give notice and it's unrebutted, that stands at law. Also, I've talked on personal matter jurisdiction, in which why I came in under special appearance the first two hearings, because at the end of the day, I'm not a legal person. I'm not in a legal capacity under Michigan law. I do not qualify as that person, which that person is a corporation, a trust, individual, in some type of legal entity of that nature, an association. I do not qualify as one of those people to be here and subjected to this without consent. Hence why, things were sent administratively and defaults were given.
Now it gets tense. Karen interrupts, claiming the court can't declare its own jurisdiction. The judge immediately warns about contempt. This is a subtle but important moment. The courtroom isn't just about debate, it's about respecting rules. Sovereign citizens frequently escalate by shouting over the judge, but here we see that power dynamics matter. A single misstep, interrupting or ignoring the judge, can lead to immediate consequences, showing viewers that theatrics only get you so far in real courts.
Burden of proof only applies in criminal cases, which is false, because the burden of proof applies in all civil cases where jurisdiction or contract validity challenged, and that's Taylor versus Bullam in 1992 in Michigan. you still have the burden of proof. The court cannot establish their own jurisdiction being based on a contract is rescinded. You have to have a valid contract to come into court about. So that's where your jurisdiction of the subject matter is at hand, because the contract is rescinded, not unilaterally, like he's tried to claim before. It is rescinded, meaning I gave you notice and it's unrebutted, just as if somebody came into the courtroom for an eviction, or if they did not come for the eviction, you'll give them a default, because what happens at law, your silence stands.
All right, thank you, Ms. Battle. Mr. Fantera, you may proceed with your case.
Plaintiff would like to call Dawn Charles as a witness.
All right, Ms. Charles, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing.
I do.
Thank you. You may lower your hand. You may proceed.
Ms. Charles, please state your name for the record.
Dawn Charles.
And what is your position with the Ranches of Rosebrook?
I'm the property manager.
Are you familiar with the tenancy of Anise Battle?
I am.
Are you familiar with the lease agreement that she signed?
I am.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024. I'd be moving for that to be admitted as Plaintiff's Exhibit 1.
Did you also provide a copy to the defendant?
I did not, because I do not have her email address. But she should, Your Honor, I should say for the record, she should have a copy of the lease, because it is, because she signed it.
Any objection?
I never received a hard copy of the lease, and I've asked for a hard copy of the lease, never received it. And as I read the lease, that was also a breach of my lease, as I was supposed to receive it and sign it in person, as they made me sign it over online. So again, the information that he's saying about the lease is correct. I'm not here to argue about the lease. As far as what the original contract was, I'm arguing about the validity of what it is now, which is invalid.
Next up, proof of service. Karen argues jurisdiction, but the court calmly walks through the evidence, multiple mailings and even posting on the tenant's door. She physically appeared in court later, acknowledging service. Here's the lesson: sovereign citizens often claim they never received notices, but courts meticulously document service. Reality check for viewers: your own imagination doesn't override official processes. No amount of "I didn't get it" arguments will bypass proper procedure. Asterisk.